Hello, my name is Jay Doolin from the Foundation for Educational Administration. Thanks for joining us for this series of live legal webinars we're presenting as an NJPSA member benefit. Our topic is a timely one, a discussion of the legal issues surrounding commencement, prayers, and end-of-year events. We're fortunate to have with us Wayne Oppito, an NJPSA attorney of many years, and a speaker on this and other legal issues in education. Welcome, Wayne. In the interest of facilitating the discussion, we've muted all phones and computers. You will be able to ask written questions by using the question box on the webinar control panel. Type in your question and we will answer at the appropriate time. We've also posted Wayne's PowerPoint on the featraining.org website for your convenience under FEA Resources. That's featraining.org under FEA Resources. Here is Wayne Oppito.
Good afternoon, everyone. As Jay said, I am Wayne Oppito. I've done this for a number of years, and hopefully will give you some guidance with regard to your end-of-the-year activities. One of the things that is not on the PowerPoint, and it looked like we were going to have an issue early in the year. Fortunately, the weather cooperated, and that's the 180-day calendar. State law requires that school districts be open for 180 days prior to graduation. Back in the winter of 1994, because of not only snow but a number of ice storms, by this time of year, districts were scrambling around because I know some Hunterdon County districts that year were only be able to be open 4 days the entire month of January. And so what happened was the department came out with guidelines saying that if you are confronted with that situation, you have to use up all available days. If that means going into your spring vacation, you go into your spring vacation. They even suggested having school on Memorial Day. And now, of course, that would require the cooperation of your Teachers Association. And some districts had to go all the way till June 30th. The department even suggested that if you were really stuck, you couldn't do 2 half days in one day, meaning you couldn't go from 8 to 12 and then from 12:30 to 4:30, unless it was a kindergarten class. But with regard to the regular classes, you had to get at least 4 hours in of instructional time for the day to count. Like I said, after the big storm we had in December, we weren't sure what was going to happen for this past winter, but fortunately we were okay. So with that in mind, let's talk about some of the issues regarding commencement, and let's start with one of the easy ones, but sometimes it's not so easy. And that's the prom. As a rule of thumb, attendance at the prom is a privilege and not a right. And the Commissioner of Education, where these cases are heard, will generally support a school district in its decision with regard to attendance at the prom. And you got to understand, at this time of the year, the Commissioner will always receive cases involving the prom, participation in class trips, and more importantly, walking in graduation. So let's start with the prom. There's a Manchester Township Board of Education case out there where the school administration determined to bar a student's date from attending the prom based on safety concerns. Now, the administration held that the girl could attend the prom, but she could not bring this one particular boy with her. The date had attended another high school, or was attending another high school, but had previously attended Manchester in the past, the district that was hosting the prom. The student's disciplinary record while at the host school was the issue. His disciplinary record consisted of numerous tardies and allegations of being under the influence of alcohol while in school. In the alcohol incident, a teacher had smelled alcohol on the student's breath and the student was sent out for testing, but the result was negative. In the proceeding before an administrative law judge, the principal indicated that the boy's mother had previously admitted that the student had been drinking. However, the mother testified she never made such a statement. Other disciplinary issues that concerned the school was an altercation on the school bus after someone allegedly made a remark about the boy's sister. And in presenting this argument, their argument, the girl and the date contended that they spent almost $1,500 in preparation to attend the prom, and much of that money was not refundable. The ALJ found that the record did not support a finding that the boy was a safety risk for attending the prom. He noted that police officers would be at the prom. Furthermore, he stated he did not believe that the boy would embarrass his date in any such way. The administrative law judge determined that based on all the equities in terms of the money, time, and expenditure of energy, it weighed in the girl's favor. The administrative law judge stated, given the importance of the prom to this generation of students, the equities clearly favor the petitioners, and with security being what it is, as being described, or what it would be at the prom, the ALJ determined that any risk is clearly outweighed by the harm imposing by keeping the petitioners from attending the proceeding. The commissioner affirmed the decision of the administrative law judge and noted that it is well established that prohibition from a prom does not in and of itself rise to the necessary level of irreparable harm. However, the commissioner went on to indicate that it was particularly troubling that the girl found out that her date would not be allowed to attend the prom by rumor rather than directly from the administration. So basically, if you're going to bar a student from attending the prom, it's a matter of being equitable with the student. Indicate why the child or why the student is not being permitted to attend, and also give the student opportunity to be heard, okay, and do it early enough so that you don't have a situation where someone says, well, I spent all this money in order to prepare for the prom. But like I said, as a general rule, the commissioner will support your decision provided you've given the student, quote unquote, due process to be heard, to be told why they're being banned, and to be heard, on their side. With regard to another case, which involved the Woodbury Board of Education, the student had a lengthy disciplinary history, including one of sexual harassment. As a result, in January of, now this case is, a few years old, but in January of 2003, the student was placed in an alternative educational setting. In a letter from the administration, the student's mother was informed that the board would evaluate the student's progress prior to June 10 to determine participation at graduation. Now, one of the things you should know is that when it comes to graduation, the commissioner will lean a little bit more towards allowing a student to walk as opposed to the prom or other class trips and the like. In February, the child had been placed in the alternative school because of his disciplinary record. That was in January. In February, the alternative school removed the student from their program because he allegedly possessed a controlled dangerous substance. With an intent to distribute, by the way, so it wasn't just merely possession. The student was subsequently found not guilty in the criminal court of that charge. But subsequent to the removal from the alternative school, the district had placed the student on homebound instruction, and he successfully completed his requirements. The superintendent determined not to permit the student to walk at graduation, and the mother appealed to the Commissioner of Education. At the hearing, the superintendent testified that the removal from the alternative school was reason for denying participation in graduation. However, the board did not act on this decision, nor was it ever communicated to the student. The homebound instructor advised the student of the decision. So the kid's finding out from his homebound instructor as opposed to from school administration. Student testified that he wanted to walk in the ceremony because of his athletic accomplishments and because many of his friends had dropped out of school while he had finished. He also claimed that the victim of the sexual harassment would not be at the graduation. She was a different grade than this student. Again, the administrative law judge allowed the student to walk at graduation. He found that the board's decision was based on the student being terminated from the alternative school. However, the underlying charge for the dismissal from the alternative school, was dismissed by the court. So basically, there was no underlying charge for the alternative school removal. So the dismissal from the alternative school standing alone was not enough to show that the student had engaged in any improper behavior. The ALJ noted that the board did not call any witnesses from the alternative school regarding the incident, and there had been no further investigations concerning that incident. Again, the administrative law judge determined that the student could attend graduation, and the commissioner agreed with the administrative law judge. The above two cases are just examples of situations where participation in graduation or the prom are privileges. They are not rights, but school administrators must comply with certain due process requirements before revoking those privileges. The district should always notify the student and the parents what the student has been alleged to have done or did not do. The student and the parent should be given an opportunity to give the student's side of the story. The punishment should be in line with the student handbook and should be consistently applied. Sometimes we get situations where it's a one-time situation for a kid who's generally a good kid, and maybe you'll let that slide, whereas another student who is been a problem throughout the course of the year or maybe even the course of their 4 years in high school, they're not given the benefit of the doubt. So you got to be consistent. And there should always be an appeal process to the superintendent, and eventually the Board of Education has to make that call, because you really understand this is that you're only as strong as the support you get from the Board of Education. All right, not seeing any questions with regard to that. I do want to get to benedictions and invocations. Basically now we're talking about student prayer issues. And even before I get into the text of what I was going to speak of, it's a very interesting, I'll call it a situation right now because it's not a case, involving Neptune High School's graduation. Neptune High School, for those of you not aware, is a community close to the shore. It's on the shore. And Neptune High School has been in existence now for, I'm going to say, approximately 75 years, if not longer. Part of Neptune Township is Ocean Grove. Ocean Grove was founded by the Methodist Church. In fact, the land that Ocean Grove is situated on is still owned by the Methodist Church or by the Camp Meeting Association, and that people who live there really leased their homes for 99 years, but in fact, the property, the land itself, not the buildings, but the land itself is owned by the Methodist Camp Meeting Association. And there's been lots of litigation involving Ocean Grove throughout the years with regard to blue laws, where they did not allow cars in Ocean Grove on Sundays. That was overturned by the courts. They used to actually, there's two large pillars when you're entering Ocean Grove, and they used to actually put a chain across at 12 o'clock midnight, Saturday night, Sunday morning. So, but what you have now is Neptune High School has traditionally, and when I say traditionally, for probably about the last 75 years, held their graduation at the Ocean Grove Auditorium. It's probably the largest all-wooden structure east of the Mississippi, if not in the entire country. But if you've ever seen the Ocean Grove Auditorium, which happens to be on the federal historic preservation sites, and it's a historical structure, there is a large cross. And you also have to understand that the Ocean Grove Auditorium is used for many secular events. Presidents have used the auditorium to give speeches. There are secular music concerts there. There are secular meetings that occur there. So understand that it is used for secular purposes in addition to its religious purposes, but there is a large cross built right into the edifice. Apparently last year, a grandparent, not even a parent, but a grandparent felt that Neptune should no longer have its high school graduation in the Ocean Grove Auditorium. The decision was, or the recommendation was made on 2 points. One was the actual, what was actually in the graduation ceremony, and the other was the site. And part of the ceremonial problem was the singing of what could be considered a Christian hymn. So the board agreed that they would take that part out of the graduation. However, they were not willing to change the site. Now understand, the challenge was not on the basis of someone who was a Muslim or Jewish, but rather the challenge is coming from someone who is an atheist. And their feeling is that the Ocean Grove Auditorium is not an appropriate place for a public high school graduation. But that's where we are right now. There's been, the ACLU has inquired with the Neptune Township Board of Education and its attorney about changing the site. However, at this point where we are right now, no determination has been made. You should know that the Ocean Grove Auditorium seats about 3,000, and so they're not worried, about having to distribute rainy day tickets if you're having your graduation out on the football field. And the other thing is, I know a number of you would hold graduation someplace else. I know the Middletown high schools use the Garden State Arts Center. I believe East Brunswick uses the RAC at Rutgers. So districts, rather than having to predict what's going to happen with regard to the weather, if there's an indoor site that can accommodate them, they've opted for those indoor sites. Like I said, the Ocean Grove Auditorium is situated in Neptune Township, and that has been a good spot as far as Neptune is concerned for having its graduation. Like I said, they've done it for about the past 75 years. So maybe this time next year when we talk about commencement, we'll have some kind of determination as to Neptune's situation. But one of the things I do want to talk about is prayer at graduation. And let me preface this, because I know some of you are at very traditional high schools and have had things in graduation that's probably have gone on longer than any of you can remember. And I'll preface it with this statement. Everything's legal until somebody challenges it. So even though you may be doing something that you've done for, as in Neptune's case, the past 75 years, it's fine if no one challenges it. But if someone challenges it, you should be aware, of what is going on out there with regard to, let's start with prayer at the graduation ceremonies. Now, there is a leading case in New Jersey, and I'll tell you how we got to that situation in terms of history of litigation. And it is a Third Circuit Court of Appeals case. It's a federal case, and it involves the ACLU and the Black Horse Pike Regional Board of Ed. Okay, that's what Black Horse Pike Regional did. They had a school district policy permitting the high school senior class to vote on whether or not to conduct a student-led prayer at graduation or not. The First Amendment to the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The Establishment Clause guarantees that government will not interfere or will not establish, a state religion or give preference to one religion over another religion or to give preference to religion over non-religion. There's a second clause, though, which we will call the Free Exercise Clause, which safeguards an individual's right to practice his or her religion within the parameters that we don't have to elaborate on here. In the context of our public school cases, the conflicts almost always come with the Establishment Clause, not the Free Exercise Clause. The first case of note is a case called Lemon versus Kurtzman. It was a United States Supreme Court case in the 1960s, and it determined that public monies in the form of stipends sent to parochial school teachers to supplement their low salaries was unconstitutional. So what you had was a state, which will go nameless right now, that wished to supplement their salaries of their parochial school teachers to try to attract better people there because the salaries were so low. And the court ruled that you cannot use public funds, public monies, to supplement parochial school teachers and their salaries, which, again, aside from our discussion right now, will be an interesting discussion if and when the voucher situation ever goes to court or ever becomes law in terms of whether you can use public monies to allow students to attend a parochial school. But in Lemon, the Supreme Court determined or applied what we would call the Lemon test, which was a three-pronged test to ascertain whether or not a public body is getting entangled with religion. Because really, even though Thomas Jefferson once said there's a wall or separation between church and state, if you look at a number of the cases, there's really not that wall of separation, but more of a gray line. And the court almost always looks at it on a case-by-case basis. But what happened in Lemon, they said, we're going to apply a three-pronged test to determine whether or not the practice would be permitted. And the first prong was, is there a secular purpose? And the second prong is the primary effect of the program, will it neither advance nor inhibit religion? In other words, it's got to be neutral to religion and non-religion. And third, does it foster excessive entanglement between government and religion? So that was the Lemon test. One of the first school cases involving school prayer at graduation was a case called Lee versus Weissman. Now, Deborah Weissman was a graduate of a Rhode Island junior high school, and the principal was Robert Lee. And the reason that it's Lee versus Weissman, because when you lose on appeal and you appeal it, all of a sudden the school district becomes the first name. So that's why the principal's name is first and the person who is challenging it is second. Generally, it would have been at a lower court level, Weissman versus Lee. Anyway, Principal Lee, in accordance with a long-standing tradition, invited members of the clergy to give an invocation and benediction at graduation. The principal stressed to whoever the clergy person was, and they used to rotate throughout the town in terms of the clergy person who would give the invocation and benediction, that it had to be non-secretarian. Now, I'm assuming when you hear the next line that Weissman was Jewish because they wanted to emphasize that this was neutral to all religions. The person giving the invocation in this one particular year that Weissman objected to was a rabbi. And the rabbi complied with all of the requirements that the principal set down for it. In fact, he used a book that is for Christians and Jews in terms of non-secular, or in terms of things that would be neutral with regard to religion, in terms of the benediction and the invocation. However, I mean, can any, if a clergy person is giving an invocation and benediction, can it really be religiously neutral? Anyway, after graduation, Daniel Weissman, who was Deborah's father, sought an injunction barring the school officials from inviting the clergy to deliver invocations and benedictions at future graduations. The lower court found that the practice of inviting the clergy to say a prayer at graduation violated the Lemon Test, and therefore it was unconstitutional. The U.S. Supreme Court affirmed the lower court holdings that the practice was unconstitutional, but didn't base its decision on the Lemon Test. Rather, the court used a different analysis. The court said the Establishment Clause prohibits state intervention in religious activities, and that the principal and the school district are really extensions of the state. Students could reasonably associate the invocation and benediction as participation in religion rather than respect for religion. And the school district may not subject its students to this dilemma of either participating or protesting against the program. The court determined that by virtue of attending graduation, students were being compelled to participate in a religious activity. The court rejected the school district's argument that graduation is voluntary and therefore there was no compulsion to participate. The court affirmed the decision of the lower courts and said that prayer performed by clergy at graduation violates the Establishment Clause. All right, so the first step we have now is you cannot have the clergy do a prayer at graduation. Okay. Even though I remember, because I'm a lot older than most of you, that we had a clergy person do a prayer at our 8th grade graduation, public school. The next case, though, because obviously the court left unanswered, well, if the clergy can't participate, what about student-led prayer? Because remember, the other part of the Constitution, we were talking about the Establishment Clause and that this was a violation of the Establishment Clause, but what about the Free Exercise Clause, where the courts and the state cannot prohibit someone from their free exercise of religion? So what you have is the situation, is it consistent with the Free Exercise Clause, for a public school to allow student-led prayer at graduation? Now, the Fifth Circuit Court of Appeals addressed this issue. Fifth Circuit is more, you know that the states are divided into 9 circuits. For our purposes right now, we're in the 3rd Circuit, along with Pennsylvania, Delaware, Maryland, and of all places, the Virgin Islands. But anyway, so we're in the 3rd Circuit. The 5th Circuit, which is Arkansas and in America's heartland, maybe Texas, I'm not sure, but in that general area around the Mississippi River and south, below Missouri. The Fifth Circuit, in what you had in Jones, was that the Fifth Circuit upheld a school district policy of having non-sectarian student-led prayer as an invocation at a public high school graduation ceremony. Okay. The court ruled that this inclusion of the prayer at graduation was at the discretion of the senior class, even though it required approval by the school principal. The Fifth Circuit applied the Lemon Test and said this: the policy had a secular purpose, the secular purpose being to solemnize the graduation ceremony. The policy did not excessively entangle government and religion. And the policy did not significantly advance religion. So therefore, the Fifth Circuit ruled that student-initiated prayer at graduation is permissible. Well, based on this Clear Creek decision, Black Horse Pike Regional in New Jersey adopted a policy permitting the senior class to determine whether the seniors wanted a prayer, wanted a moment of reflection, or nothing at all to be included in the graduation ceremony. When we say a moment of reflection, a moment of silence. A plurality of the seniors voted to have a student-led prayer. However, the majority wanted either a moment of reflection or nothing at all. So we're talking about not a majority of the seniors, but only a plurality of the seniors. The American Civil Liberties Union and the senior class student filed an action, because they had to have a student who would be opposed to this thing, to enjoin student-led prayer at graduation. The district court denied the request, but a two-judge panel on the Third Circuit Court of Appeals, which, remember, New Jersey is controlled by the Third Circuit. The Third Circuit reversed and temporarily entered an order stating that prayer could not be had at the graduation, and enjoined the Black Horse Pike Regional Board of Education from conducting a graduation ceremony that included prayer, whether it was an invocation, a benediction, or some other form. Now, the board appealed this decision by the two-judge panel of the Third Circuit to the entire Third Circuit. That's what we call en banc, the whole thing as a whole. And the Third Circuit, sitting as a whole, determined that the board's policy of allowing the senior class to determine whether prayer would be included in the class graduation ceremony was unconstitutional. The Constitution guarantees government may not coerce anyone to support or participate in religion or its free exercise thereof. Individual freedom of religion, protected by First Amendment, embraces the right to select religion of any faith or number of faiths, or no religion at all. The board's emphasis on permitting a majority of the students to decide prayer, whether or not to have prayer, was misplaced. The court went on to say, and it wasn't even a majority, it was a plurality. The policy allowed 128 seniors to impose their will upon 140 classmates who wanted different choices or did not want prayer at all. The policy ignored the right of others to worship in a different manner or not to worship at all. And the First Amendment does not allow one's religious preferences to be compromised in this manner. Court reasoned that the Board of Education policy could not broaden the freedom of speech rights of students at graduation, nor convert the graduation ceremony into a public forum. High school graduation is not regarded as a public forum where a multiplicity of views on any topic, secular or religion, may be expressed or exchanged. The board retained a degree of control over the remaining student speeches at graduation, whether it be the valedictorian, the salutatorian, the class president, or whoever. There was still a degree of control over those speeches. The policy allowed the seniors, again, to determine the prayer issue, which could not be legitimized as promoting the free rights of the students. When the senior class received control over a segment of graduation, the senior class was just as constrained by the Constitution as the local Board of Education. So although the government involvement in student-led prayer is less evident than in Lee versus Weissman, the student referendum did not erase the government's imprint on graduation prayer. And when we're talking about government, we're talking about the Board of Education. Graduation is a school-sponsored ceremony with the school officials deciding the sequence of events and the order of the speakers. Ceremony is typically held on school property, except we know not in Neptune, and at no cost to the students. The Board of Education has, in every practical sense, compelled attendance and participation in an explicit religious exercise at an event of singular importance to every student and their families, and at which objecting students had no alternative to avoid. The Board of Education could not sanction coerced participation in a religious observance merely by disclaiming responsibility for its content. The full Third Circuit held that contrary to the Fifth Circuit's result, based on the concept that this is a once-in-a-lifetime event, it's unpersuasive. The uniqueness of the event does not justify a public school authorizing collective prayer. The significance of the graduation ceremony weighed heavily in favor of invalidating the prayer because students were denied the option of foregoing the ceremony to avoid compromising their religious scruples. All right, so what do we have in light of Black Horse Pike Regional and Lee versus Meisman? Very clearly, prayer presented by the clergy at graduation is unconstitutional and not permissible. Student-initiated prayer, at least at graduation in New Jersey and the other states included in the Third Circuit, is not permissible as a result of the Black Horse Pike Regional decision. In Lee, the Supreme Court left no doubt that it remains unconstitutional to have a moment of silence offered by the clergy at graduation. It was not decided whether a student-initiated moment of silence at graduation is permissible. We do have a statute in New Jersey that very few people remember even exist, that the school day was supposed to start off with a moment of silence. What happened, though, in the sponsor statement, it clearly said that the moment of silence was for the students to pray. And when Saul Cooperman was the Commissioner of Education, it was challenged. And in the Cooperman decision, the state moment of silence law with regard to the opening of school in the morning was held to be unconstitutional. But if the students decide to have a moment of silence or moment of reflection at graduation, to think back on our 4 years, or our 12 years together, there's no decision one way or another about that. And I think as long as it's not indicated that the moment is for prayer, the likelihood is that something like that would be permitted if challenged. Left unanswered, though, by any of these decisions, are baccalaureate ceremonies for graduating public school students. Okay. Baccalaureate ceremonies are religious in nature. Right? If attendance is strictly optional and there's not the same expectation of attendance on the seniors that would apply, like, say, to graduation, then, it would be permissible. However, you're strongly advised and cautioned, avoid school sponsorship of a baccalaureate. It can be held in one of the houses of worship in the community. It's strongly recommended that the public school not sponsor the baccalaureate. It is a better choice for the baccalaureate to be held away from school grounds with the sponsorship by some outside organization who can invite your graduating class. With that, that gives you an idea of what's going on out there. Just caution in terms of student prayer. I know that some of you at some very, very traditional high schools have done certain things from time immemorial, since probably longer than you were born. But like I said, if someone challenges it, know what the parameters are out there. And unless we see some questions, Jay's going to say one final word. I do want you to know that the substance of this presentation is on the FEA or on the PSA website. It's on the PSA website, and if you click on it's entitled Commencement 2011, and we update it every year because obviously this comes about every year. So with that, I thank you all very much.
Thanks very much, Wayne. We'll take a minute. Does anyone have any questions? You can type a question real quickly on the question area of the webinar control panel. Okay, we don't see any questions. So let me thank you, Wayne, for providing, I think, very important information about end-of-the-year ceremonies I learned things that I hadn't known. And thanks to all
That's
of you.
only because you're a lot younger than I am.
Right. Thanks to all of you for taking the time to be with us today. Be sure to register for the May 17th webinar, Special Education Law and Discipline, and David Nash is going to be with us on then, May 17th. Well, thanks again, and thanks very much for being a part of this.
And if you think of any questions that you haven't thought of right now, you can always call the association offices and ask for me, and I'll be glad to help you where I can. So have a good afternoon, everyone.
Yes, thank you.